Okay, I want to talk about the U.S. corporation and the bankruptcy cycles. U.S. law is private merchant law, leaving the people as surety and debtor on the national bankruptcy. All law is contract, universally, and in the United States. So we must follow the progression of the contractual agreements which constitute the underlying U.S. law. We cannot address all individual laws and cases, for it would take a lifetime to review them all, even though ignorance is no excuse of the millions of laws, statutes, and codes, etc. on the books in the private admiralty jurisdictions. And basically in chronological order, the following progression of contracts and our interpretation of them as follows. The United States, the USA, a corporation of the English Crown, is bankrupt and has been since at least 1788. The Articles of Confederation states in Article 12, all bills of credit, emitted moneys borrowed, and debts contracted by or under the authority of Congress before the assembling of the United States in pursuance of the present Confederation shall be deemed and considered a charge against the United States, for payment and satisfaction whereof the said United States and the public faith are hereby solemnly pledged. That was the Articles of Confederation. So soak that up and drink that in for a minute. And the founding fathers, as constitutors, acknowledged, and look in your Black's Law Dictionary what a constitution is, and what a constitutor is. It's not what you think it is. Anyway, the founding fathers, as constitutors, acknowledged and recognized the debt in the United States Constitution, 1787, Article 5, hence Constitution. Bankruptcy occurred on January 1st, 1788, based on 21 loans that the United States of America received from the King of England, dating from February 28, 1778 through July 5th, 1782, the repayment of which had been ratified by Congress on January 22nd, 1783. The United States Bank, created in 1791, was a private bank with 18,000 of the 25,000 shares owned by England. No de jure constitutional Congress has existed since March 27, 1861, when 7 southern states walked out of Congress, leaving Congress without a quorum for adjourning, and therefore ending sine die. That which is called Congress today assembled and acts under the authority of the President, acting in capacity of being Commander-in-Chief of the Armed Forces under emergency war powers rule, i.e. law of necessity, i.e. no law. C-12 Stat 319, which has never been repealed and exists in Title 50 United States Code, subsection 212, 213, 215, Appendix 16, 26 CFR Chapter 1, subsection 301.16a. Since the above reference date, March 27, 1861, Americans have been under fascist rule by a presidential executive order under the aforementioned Emergency War Powers Act. Every citizen of the United States is now legally established as an enemy via the Amendatory Act of March 9, 1933, 48 Stat 1, amending Trading with the Enemy Act of October 16, 1917, House Resolution 4960, Public Law Number 91. On December 6, 1865, the 14th Amendment was proclaimed as ratified, even though it never properly was. The 14th Amendment, which is a private Roman Catholic ecclesiastical trust law, constitute a constructive Sustakay v. Trust, a public charitable trust, or PCT, that was expressly designed to bring every corporate franchise artificial person called a citizen of the United States into a inseparable merging with the government until the two are united with power held by the government, not the people. A Sustakay trust is a fundamentally different form of regular trust, which is express, which means clear, definite, explicit in nature, and consists of a contractual indenture involving 3 parties, a grantor, which is the creator or trustor, a trustee, and beneficiaries. In an express trust, legal ownership is transferred by written contract between a grantor and trustee, in which the grantor surrenders ownership of property to the legal person. the trust, to be managed by the trustee on behalf of those who are to benefit from the arrangement. The beneficiaries, a Sestake trust, on the other hand, Sestake trust differs from an express trust in several crucial ways. It's not formed by express contract, i.e. overt agreement expressed in writing, but by legal construction, i.e. fiat. A Sestake trust has no grantor, but being a constructive trust created by operation of law, i.e. by make-believe, has only co-trustees and co-beneficiaries, and co-trustees are the parties with the duties for managing property for the public good, i.e. for the benefit of those designated as the co-beneficiaries. The Legislative Act of February 21st, 1871, 41st Congress, Session 3, Chapter 62, page 419, chartered a federal company entitled the United States, aka U.S. Inc., a commercial agency originally designated as Washington, D.C. in accordance with the so-called 14th Amendment, which the record indicates was never ratified. See Utah Supreme Court cases, Diet versus Turner, as well as Coleman versus Miller. A citizen of the United States is a civilly dead entity operating as a co-trustee and co-beneficiary of the PCT, the Constructive Sestake Trust of the U.S. Inc., under the 14th Amendment, which upholds the debt of the USA and the U.S. Inc., Section 4 of the 14th Amendment. In conformity with the above referenced creation of the United States in 1871 and the 14th Amendment, the legislature of each state created a limited liability corporation chartered in a private military international commercial admiralty maritime jurisdiction entitled State of, for example, State of California, all capital letters, as evidenced by inter alia, the charge in the seal, and the creation of the new Constitution, for example, Constitution of the State of California, 1879, concerning which reference California. A general partnership agreement hereinafter. General partnerships exist between the California Republic, 1849, and the State of California, 1879, all capital letters, with the State of California, all capital letters, acting as governmental controller. So they set up sub-corporations under the original U.S. corporation. And it's interesting, if you look back at the Wizard of Oz movie that came back, or the book or whatever, it came out in the 30s, and they say you're no longer in Kansas anymore, because Kansas was the first state after the enactment of the Federal Reserve Act, was the first state where they set up the first Federal Reserve Bank. And they were no longer in Kansas because they went to the corporate Kansas, which is KS, which is the abbreviation. So, moving forward here, the State of California, all capital letter, now acts as an agent, instrumentally of the United States, collecting whole life insurance premiums known as taxes for the International Monetary Fund, based inter alia upon the Limited Liability Act of 1851 and the Bankruptcy of the United States of 1933. See House Joint Resolution 192 of June 5, 1933, Public Law 73-10, Perry versus U.S. Inasmuch as all law is contract, the contract involved in the constructive trust is an implied contract. An implied contract can be ratified by two means: acquiescence by silence, and asserts its intentions concerning your life, rights, and property, and you assent, don't rebut, and compliantly go along with what they claim. In 1871, the government changed the nature of its contract with the people from law as defined by the original Constitution of 1787 that recognizes law, common law, admiralty on the sea only, and equity functioning by voluntary contract between all participating parties, and began relating to the people as if they were citizens of the United States within, under the private, commercial, international, military jurisdiction of the new de facto corporation, i.e. the U.S. Inc. They offered the people a new deal for almost everyone And almost everyone bought into it based on the not naive and foolish trust and assuming that everything was okay. The people were thereby denied access to law and placed on the ship of state of the U.S. Inc., where the captain's word is law and no one has any rights. As Jefferson phrased the matter, the government grows, liberty recedes. You expressly accept benefits offered by the government and thereby finalize the contract by deed. This is similar to finalizing the contract with a restaurant by sitting down at a table, reading a menu, and then ordering and consuming a meal. By your deeds, you affirm to the restaurant that you will pay for the meal in accordance with the price stated on the menu. No written contract is signed, but the contract is formed nevertheless. And that's what we have in this country now. So if you take if you use your Federal Reserve notes, or you sign up to, you register to vote or anything like that, get a marriage license, you're automatically accepting that you'll under their contract that you acquiesce to it. And also, it's funny too, if you're using private international the private international monetary system, you're automatically assumed to be an expert in private international law and these monetary notes that they use. So you're using it, you must be an expert. By the above two means, people give implied assent that they are bound by an alleged contract with the United States Inc. in accordance with the items and conditions that adhere in being treated as a citizen of the United States under the 14th Amendment, and are therefore placed into a permanent legal status as a debtor and the surety for the U.S. Inc. In such a position, people leave the ground of sovereignty and all the capacity of asserting their unalienable rights in favor of being presumed as having exercised their sovereignty and free will and autonomy for the purpose of going along with the government's assertion that they sacrifice everything for the public good, i.e. the PCT. By so doing, people lose their standing in law, i.e. they die a civil death in law. They are placed in a legal position of mortmain, i.e. as if deceased, and are shorn of capacity for asserting their rights. Since the perception is that they have already exercised those rights for the purposes of being placed in the position they are in, i.e. property of the government, with a lien against them, and everything their lives of labor could ever create, including children, the private being the real individual, is sacrificed for the good of the public, the imaginary collective. When people die such a civil death in law, they are like ghosts and thereby incapable of managing their own affairs and enjoying their unalienable rights. Like the estate of a decedent, they are then managed by the executors, administrators of the estate in probate. Such is the condition for every citizen of the United States today in law, managed by the government agencies acting as executors, administrators of their estates in bankruptcy, legal incapacity, and civil death as assets of the bankruptcy of the United States. The U.S. is property of the private real property of interest, the creditors of the bankruptcy. The 14th Amendment was allegedly established for the purpose of creating a citizenship for liberated blacks, the other disenfranchised people, who otherwise had no citizenship because they could not comply with the requirements of state citizenship. What actually happened was that the blacks were taken off the southern slave plantations and placed into the slave plantation of the U.S. Inc. And far worse, the government and gradually absorbed everyone else, including state citizens, into the same condition. So in 1871 to 1913, officers of the actual government had office in dual capacity, i.e. both the USA and the USA Inc. status. 1912, bonds issued by the U.S. Inc. came due, but the U.S. Inc. did not have the resources for paying its creditors, the 7 families that founded the Federal Reserve Bank. So the U.S. Inc. owners, the actual government, was required to pay the balance. The national government was also without sufficient funds to meet the U.S. Inc.'s obligations. So the creditors settled for all the assets of both U.S. Inc. and the national government instead of foreclosure on the liquidation on the entire country. By so doing, they expropriated the nation, both the USA and USA Inc., the Republic and the democracy. So in 1912, U.S. Inc. forms an agreement with the Federal Reserve Bank. It's important to note that both of these entities are private corporations, which removes the general allegations of treason or fraud from this relationship. Through this agreement, U.S. Inc. must function in debt, even though it has neither funds nor resources for financing its operation. So in 1912, the first corporate-only senators are seated in the next election year by popular vote. The U.S. Inc. registered voters. The original jurisdiction national senators of the United States did not assume office that year, and at least one-third of the nation's senator seats were lawfully and voluntarily vacant. February 3rd, 1913, U.S. Inc. passes the 16th Amendment, and Congress orders the Secretary of the State to enter it as ratified, even though the states had not ratified it according to law. The Secretary complied. It should be noted that this would have been lawful if it were not a national constitution amendment. However, it was perfectly legal with the colorable de facto corporation. It should also be noted that where the national constitution already had a 16th Amendment, and where Supreme Court says that the new 16th Amendment did not do anything, this corporate amendment must simply be space filler. Entered such U.S. Inc.'s Constitution 1871 would have the same number of amendments that the national constitution did. April 8th, 1913, U.S. Inc. passes the 17th Amendment, and Congress orders it to be entered in as ratified in the exact same manner that they did with U.S. Inc.'s 16th Amendment. This amendment changes where U.S. Inc. senators are elected. This amendment is not even lawfully possible as a national constitution amendment for several reasons, not the least of which is that the amendment would have required that Congress first pass an amendment that stated that they had the power to say where senators are elected before they could even deliberate on such a subject matter, after which they have to have competent ratifications performed on such amendments in accordance with constitutional limits, not as was done with the U.S. Inc. 16th Amendment. Going on here, December 23rd, 1913, the Congress, late at night, we all know this, with only a small cadre of supporters present, passed the Federal Reserve Act, surrendering the creation and management of the nation's currency into the hands of the cartel of private, mostly foreign bankers. Currency is the single most essential and critical commodity in the world, embodying more law and principles of business and commerce. Is currency. Money is, in a very significant sense, the measure of all things. by abandoning control, managing the money supply of the nation, it surrendered all capacity for claiming sovereignty. The government lost its independent treasury, one of the requirements of law for national sovereignty. The United States government became a mere fiefdom, or administrative arm of the bankers who now own the store. Passage of the Federal Reserve Act was a major milestone on the road to serfdom. That is, the entire progression outlines the conspiratorial nature of the matters exemplified in comments. One of the major actors in the triumph of the Federal Reserve, Edward Mandell House, who had this to say in a private meeting with President Woodrow Wilson. He said, "Very soon every American will be required to register their biological property in a national system designed to keep track of the people, and that will operate under the ancient system of pledging. By such methodology, we can compel people to submit to our agenda, which will affect our security as a chargeback for our fiat paper currency. Every American will be forced to register by suffering. Every American will be forced to register or suffer being unable to work and earn a living." That's basically true. I mean, we look around and we see all this is happening. You have to have a license to do anything now. You have to license to drive a car, drive a cab, sell real estate, sell stock, cut hair. I mean, it goes on and on. And plus, no one will hire you now unless you show them your Social Security card and you sign a W-2 or a 1099 form. So you'll be suffered to earn a living. They will be our chattel, and we will hold the security interest over them forever. By operation of the law merchant under the scheme of secure transaction, Americans, by unknowingly and unwittingly delivering the bills of lading to us, we will be rendered bankrupt and insolvent forever, to remain economic slaves through taxation secured by their pledges. They will be stripped of their rights and given a commercial value designed to make us a profit, and they will be none the wiser. For not one man in a million could ever figure out our plans, and if by accident one or two of them should figure it out, we have in our arsenal plausible deniability. After all, this is the only logical way to fund government, by floating liens and debt to the registrants in a form of benefits and privileges. This will inevitably reap us huge profits beyond our wildest expectations and leave every American as a contributor to this fraud, which we'll call social insurance. Without realizing, every American will insure us for any loss we may incur, and in this manner every American will unknowingly be our servant, however begrudgingly. The people will become helpless and without any hope for their redemption, and we will employ the high office of the president of our dummy corporation to foment the plot against America. That was in 1917. And I'm going to leave it there. That's part one of this discussion. I'm about halfway through. Take a break and come back and do the rest. StopThePirates.blogspot.com.